And welcome back inside the law. I'm your host, Philip Holloway, joining you from the secret underground lair. We have to talk about the supplemental motion to recuse Judge Glanville, filed by Young Thug's attorney, Brian Steele. For those of you who have been following along this case with us here inside the law, you will remember that Judge Glanville, he did a 180-degree turn. He seemed to be dug in. He seemed to be entrenched in his position that he did nothing wrong. And by the way, how dare you, Brian Steele, question my having this ex parte communications with the prosecutor and a witness in the case without telling anybody? How dare you? And by the way, if you don't tell me how you found out about this, I'm going to throw you in jail, Mr. Steele. Yeah, that's all the sort of nonsense that we've been seeing that's going on in this Young Thug YSL trial. And now, of course, it's on pause. It's been on pause for several days. And Judge Krause, who is another Superior Court judge, has ordered the state, they're supposed to file their responsive brief as to why Judge Glanville should not be kicked off the case. And by extension, why that ex parte communication was not illegal. And I'm going to tell you, I'm glad I'm not the one that has to make that argument, because in my opinion, as I've said here before, that ex parte communication was unlawful. It was unethical. There's some limited exceptions that allow for ex parte in very, very, very limited circumstances. None of them apply here. But this is something that I decided to do at the spur of the moment almost, because I was reading over this over the last couple of days. I've read over this supplemental motion to recuse Judge Glanville filed by my friend and colleague Brian Steele. And I've got to tell you something. Listen, if I ever need anybody to write me a nasty letter as a lawyer, I'm going to get Brian Steele to do it, because that man knows how to use the English language. This PDF version I have is 238 pages, so we're not going to go over all of it, but I did spend some time highlighting some things that I thought were important. It's a supplemental motion to recuse Judge Glanville. What can we learn from this? Well, under Georgia law, if a lawyer has reason to believe that a judge has done something worthy of having him or her recused or removed from any particular case, the lawyer only has 5 days to file something to take some action. Otherwise, it's waived. We had this ex parte communication taking place. Eventually, Judge Glanville got around, after lots of legal maneuvering and lots of pressure. Nevertheless, he did come around to releasing the transcript. And there's a question about whether it's the entire transcript or not, but he released a transcript of what happened in his chambers. The lawyers, of course, doing their job, went through and read all of that transcript, and they've discovered some other things. One thing that stood out to me when I looked at this supplemental motion to recuse, I don't know if you can see, but right here you've got, I've never seen a footnote reference right here. It says 1, 2, and 3. It's got footnotes 1, 2, and 3 in the title to a pleading. So that was certainly creative. The substance of the motion, a lot of it's the same. It talks about why you shouldn't engage in ex parte communications, why it's unfair. This puts me on notice to look in the footnotes. And here we go. In the footnotes, I mean, he comes out of here swinging. Listen, it says this motion applies here. See, it's not only to Judge Glanville now. This motion applies to Assistant DA Love and Hilton. And Brian doesn't even refer to them as Assistant DA. He calls them lawyers, Love and Hilton, in addition to Judge Glanville. Now, normally when Brian Steele refers to a judge in writing or orally, it's almost without exception, he refers to everybody as honorable this and honorable that, and honorable court, honorable judge, honorable, even attorneys. He refers to us as the word honorable. It's just a polite way of addressing members of the profession. He doesn't say honorable lawyers Love and Hilton or honorable Judge Glanville. He says all three of these people are material witnesses now in the case at bar, and they all will be called by Mr. Williams during trial, if it ever picks back up, to show judicial and prosecutorial misconduct. So he's alleging now prosecutorial misconduct. And so he's trying to get these assistant DAs off. And he doesn't say the entire Fulton DA's office, but he does say that he wants these two lawyers off the case. Footnote number 2, moving right along, says this motion also timely moves to recuse Honorable Judge Krause, based on the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's reelection campaign. Now, let me stop there for a second. It's not uncommon for lawyers or even judges to make political donations to other judges. In fact, it can be fairly common. But $2,000 is not an insignificant one. It's not like, we saw in the Donald Trump RICO case, there was a kerfuffle about Judge McAfee having donated between him and his wife a total of $500 before he was a judge to Fannie Willis when she was running for DA 4 years ago. But this is a $2,000 donation from Judge Glanville to Judge Krause, and it was made in April of 2024 while this trial was going on. Again, there's nothing wrong with the donation per se, but it could give them a reason to doubt whether or not she can be completely objective, considering the fact that Judge Glanville recently made a very large donation to her campaign. Now, the next part that's highlighted, they cite some case law, and they say that would justify Judge Krause removing herself from the case because it gives the appearance that maybe she can't be impartial. Judge Krause has already denied that aspect of this motion. So Judge Krause, who is a colleague on the Superior Court bench with Judge Glanville, has said she will not recuse herself, nor will she recuse the entirety of the Fulton County bench, as she was requested to do by Doug Weinstein in another filing of his. Whether she should or shouldn't, I personally think that all of the judges in Fulton County should have recused themselves, and they should have brought in a judge from somewhere else. Judge Glanville, being the chief judge, while he is not her boss, he's a fixture. He's been there a long time. And, I would imagine that he carries a lot of weight amongst his colleagues. They're all independent elected officials. And so they all get to, make their own decisions. It's not like Judge Glanville can fire her or can take her pay away from her or take any punitive action. They are equal in terms of their authority and their power. The chief judgeship rotates amongst all the judges periodically, whether it's every year, every 2 years, whatever. So being the chief judge means that you've got some additional administrative roles on the court. And so they share that, and they rotate it around, and whoever the chief judge is gets a little bit of extra money in their paycheck for being the chief judge. But again, that's something that's just for administrative duties. He does not have any direct control or supervisory role over Judge Krause. I like footnote number 3. The undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done though the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. I love it. A motion to recuse, he reminds us, is timely filed if it's filed within 5 days after the affiant. That's the person who has to attach the affidavit at the end, which is Brian Steele and his co-counsel. They filed the affidavit. That's part of this 233 pages. Within 5 days, not including the weekend, that's when they had the opportunity to look through the transcript of the ex parte. So it says, thus, this supplement to motion to recuse is timely filed, as the additional reasons for recusal were first learned on Monday, July 1st, when Judge Glanville permitted the court reporter to release the transcript of the Monday, June 10 ex parte meeting between Glanville, Hilton Love, the Honorable Attorney Bumpus, and her client, sworn witness Kenneth Copeland, and others, that being sheriff's deputies. And he goes on to say Glanville's ex parte with a sworn witness means Copeland is already under oath. And by the way, all judges, including Glanville, always tell all witnesses, including Copeland, is don't discuss your testimony with anybody during a recess or when you're not here. If you're still technically on the stand like Copeland is, he's been admonished not to discuss his testimony. I am told that happened as well in this case. So Glanville's ex parte communication with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives with the Fulton County DA's office are seemingly only partially captured by the court reporter. So we have an allegation here that the transcript might have been incomplete in some way. He doesn't necessarily say that it's been redacted in any way, but maybe some things that happened off the record where the court reporter wasn't taking it down. We got to bring these people into court like Brian's going to ask Judge Krause, have a hearing with evidence, get the court reporter, get Glanville, get everybody who was there to testify under oath about what happened. Judge Glanville has not acted as a judge, but has morphed into an essential part of the prosecution team. Superior Court Rule 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Yet Judge Glanville participated in these ex parte communications and then somehow attempted to keep it secret by referring to the meeting as, quote, privileged. The judge came out and said, "How dare you learn about my privileged ex parte?" And I remember thinking at the time, and we talked about it here, what privilege are you talking about? There's no attorney-client privilege that would apply. There's no marital privilege. There's no psychotherapist-patient privilege, no other legal privilege that would cover an unethical ex parte discussion with prosecutors. And he described the improper secrecy as sacrosanct. Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. We haven't exactly seen this legal ism presented before. And it's true, though, by the way. Ex parte communications are presumed to be harmful error. So when you look at types of error that you might find in a trial, that when you appeal something, you urge the Court of Appeals to say the judge committed this error or that error, which require a reversal. Well, not all error is equal. Some error is considered harmless error, and it will not result in a reversal. Harmful error will. They point out here that ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Remember, we talked in the very beginning of this stream about the state having their response due. This is part of what they have to show, folks, is that the error would be any error. Either, first off, they have to say, well, it wasn't error, Judge, but even if it was error, it's harmless error. And I don't know how you do that. Pleasure I get in reading this filing is the footnotes, more or less, because he cites the Merriam-Webster dictionary. Sacrosanct means holy or sacred, inviolable, immune from criticism. The ex parte communications were illegal, immoral, unethical, and diametrically opposed to sacrosanct. Glanville embraced his view that the communications at this ex parte were privileged. He goes on to point out that once a party, in this case the defendants, have shown that a judge has received ex parte communications, there is a presumption of harm. It's a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. Well, hell, we know Glanville considered it. He's gone on and on and on the record talking about considering it. He threw a man in jail, or he tried to, because he considered it and because the person called him out on it. I don't know how the prosecutor can overcome this by making any kind of affirmative showing that the judge did not consider it. There is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in Exhibit B, resulted in harm. Exhibit B is the transcript of the ex parte communications. Judge Glanville therein acted as an advocate for the Fulton County DA's office as he dispensed legal advice and supported lawyers Hilton and Love's goal to have Mr. Copeland testify against Mr. Williams and other co-indictees. It is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Brian Steele is calling Judge Glanville a de facto prosecutor. and he's doing it publicly, and he's holding nothing back. And he's not wrong. I mean, it's obvious that Glanville has, in my opinion, abandoned his judicial role here. But here I found that this was interesting and wanted to share it with you. He says the improper influence and interjections by Judge Glanville, and he's talking about what is revealed in the transcript of that ex parte. He says the improper influence and interjections by Judge Glanville and his two cohorts. He refers to them as cohorts from the Fulton County DA's office on Mr. Copeland changed Mr. Copeland's stance not to testify against Mr. Williams. If Mr. Copeland refused to testify, all of his prior false inculpatory statements, that's an inculpatory as opposed to exculpatory. Inculpatory is a statement that would cast an allegation of guilt on someone. Inculpatory statements as to Mr. Williams would not come into evidence based on Mr. Williams' constitutional right to confrontation. In other words, if he takes the fifth, the defendants don't get to question him about all this other stuff. Intimidation tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, Lawyer Love, and Lawyer Hilton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. Mr. Williams, that's young thug, needs to examine, that means question, Judge Glanville, Lawyer Hilton, Lawyer Love, and all other members of their prosecution team to reveal the date and time of every ex parte communication. Were there others? Seems like Brian is seeming to suggest that he has a real question about whether or not this is not the first time. The date and the time of every ex parte communication that occurred concerning Mr. Williams' case since its inception. The subject of the same, and order the court reporter to produce any transcript of these things and to unseal all documents from these potential improper ex parte communications. The undersigned counsel needs to cross-examine all of these parties to ensure that the sworn testimony is spread in open court on the record. He cited footnote number 7. Undersigned counsel, that's Steele, objects to a proffer by Judge Glanville, Lawyers Love and Hilton. Other objections to proffers will be made at the time of the attempted proffer. So what this means is that Brian Steele is saying, look, I want them under oath in open court where I can ask whatever questions that I need to get to the truth. Now, what a proffer is when basically, let's just say Judge Glanville types up something and says, here's what happened in the ex parte meeting. And he spills out a narrative, files it with the court, signs it, maybe even notarizes it. That would be a proffer, but you can't cross-examine a proffer. That's why Brian Steele says, I need to get these people in court under oath and question them. Proffer is not good. Same for the lawyers. If they try to make a proffer, that's not good enough. I want them in court under oath. Judge Glanville has automatically caused his recusal and disqualification for Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting the affiant's allegation of judicial bias. The affiant being Brian Steele. So Judge Glanville, it says, has automatically caused his recusal when he presented argument. And remember all these things where Glanville was debating whether or not he needed to be recused, okay? This is when it says that when he presented argument refuting the allegations of judicial bias. Remember when Glanville's saying, you're just doing this because you don't like my ruling, okay? The judge is not even supposed to oppose it. He's just supposed to look at it and make a ruling. But instead, he's getting involved in this dispute over, and he's presenting arguments in his own defense, Glanville is. He's not supposed to do that. Mr. Williams respectfully requests a hearing as he will call Glanville, Love, and Hilton as witnesses to fully unmask this above discussed misconduct as well as further misconduct that may have occurred. You know, do you get the feeling that maybe Brian Steele knows something that the rest of us don't? He keeps alluding to other things, but he's dropping these little hints as like further misconduct that may have occurred. This judicial and prosecutorial misconduct denotes a disgraceful episode in the Fulton County courts, the Fulton County DA's office, and stains courts throughout the state of Georgia and our country. Justice faces its greatest threat when courts dispense it secretly. Our system abhors star chamber proceedings with good reason. A star chamber, the star chamber, the one that was infamous, was back in old England before the United States even existed. There was a secret court that the King of England had put in place, and basically it's where they brought people in secret, and it was like a court of inquisition, and most people didn't come out alive necessarily. It was not a court of any, at least not in the way we think of courts now, and that's why in America our courts are supposed to be open to the public. And that's why what this means, justice faces its greatest threats when courts dispense it secretly. Sworn to in Exhibit A, Glanville, Love, Hilton conspired to conceal and suppress Brady evidence. What is Brady evidence? Brady comes from this case, Brady versus Maryland, that he cites here. It's exculpatory evidence. It's evidence that tends to show something other than guilt or the innocence of the accused. And by law, and as a matter of constitutional law, federal constitutional law, due process requires that Brady material always be provided to the defense. Makes sense, right? So if you got a witness back there in the judge's chamber saying he's going to come out and tell lies, and by the way, he committed all these other crimes, that's Brady material. They must hand it over. Okay. He goes on to refer to it as a star chamber again. This star chamber cannot prohibit Brady evidence from coming forward. That's exactly what Glanville, Love, and Hilton planned to do. Mr. Williams' constitutional right to due process, a fair tribunal and fair trial, and the effective assistance of counsel, right to cross-examine, right to hear, see, and be present for the statements of sworn witnesses have all been not just violated. He uses the words obliterated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. I mean, you can't find something that is more powerful language than that. He's not pulling any punches here. This trial is wholly broken and can never be repaired. And I've said the same thing myself for a while. I don't see any coming back from this. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct of Judge Glanville, lawyers Love, and Hilton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of the supposed he calls him the supposed judge. So what's legally important about that? Okay, so normally if a defendant makes a motion for mistrial, then you can retry the defendant. It's not that retrial is not prohibited by the double jeopardy clause. But if the defendant is essentially forced or goaded is the legal word into making a motion for a mistrial, and it's granted because of something that the state caused or the judge caused, then double jeopardy would bar any subsequent prosecution. So that's what this legal significance is of that language. But I thought it was really, really, it's just funny. I was going to say unusual, but let's call it what it is, folks. It's funny. Glanville at the indecorous Star Chamber ex parte meeting, legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of impropriety, which is a proper ground for granting this motion. Actual bias, as Judge Glanville has embroiled in this trial and is assisting the prosecution in an attempt to gain the conviction of Mr. Williams. It's impossible for any reasonable person to believe that Glanville is neutral. And I must agree with him, in my opinion. Neither Glanville, Love, or Hilton uttered a word that they spent the morning of June 10th, 1, leaning on Copeland to testify for the prosecution. 2, coaching Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify. 3, coaching Copeland on how to deliver his testimony. And 4, promising Copeland that he would not be prosecuted even for perjured testimony unless he told a, quote, bold-faced whopper. These public officials heard and failed to reveal that Copeland confessed to committing every indicted offense in this case. Glanville should not be rewarded with the opportunity to continue to preside as judge over Williams' trial. Glanville, Love, and Hilton made themselves witnesses when Williams, whom Mr. Williams' counsel will call These three lawyers must be recused and removed from this case. I want to jump down to this footnote number 8 real quick and see what it says. Mr. Williams' counsel has announced in open court that he will call these three offenders at trial. Now he's calling them offenders. Mr. Williams' counsel has announced in open court that he will call these three offenders at trial. Judge Glanville's, Lawyer Love, and Lawyer Hilton's names appear on Mr. Williams' filed 8th amended list of witnesses. It's important to note that Glanville originally denied Williams' request for access to the ex parte hearing transcript, keeping contents of the record totally hidden by Lawyer Love, Hilton, and Glanville. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by Love, Hilton, and Judge Glanville worked to effect change. So he says that Hilton, Glanville, and Love, since they engaged in gross misconduct, but violation of oath of office is a felony crime. By the way, if you're a government official, you take an oath of office, and that includes prosecutors and judges, right? Ethical violations can cost you your elected office. It can cost you your bar card if you're an attorney. Potential criminal conduct by Love, Hilton, and Glanville. What kind of mounting pressure could he have been referring to? Let's suffice it to say, Judge Glanville wasn't watching this channel. That's not what did it. But something got his attention, and it got it in a significant way. Paragraph 23, undersigned counsel has never been afforded the questions that Hilton or Love created and gave to Copeland. Undersigned counsel has never been given this list of questions, even though Glanville has been made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review them together to understand those questions. The question must be asked, why Glanville has ex parte access to Attorney Hilton and or Lawyer Love's question for a witness. This conduct is beyond repair. There appear to be communications not captured on the transcript of the June 10th, 2024 ex parte meeting. Lawyers Love and Hilton and Glanville's examinations are needed to complete the record. Again, he's saying, Judge Krause, I've got to get these people under oath. We got to have a hearing. Glanville is a necessary witness in Williams' trial, and his name will be used when the undersigned counsel cross-examines Mr. Copeland. And here he's talking about if we ever resume a jury trial. He's talking about in the criminal jury trial. He's going to call Glanville. His name will be used when the undersigned counsel cross-examines Copeland when asking questions, whether Glanville pressured Copeland to testify, whether Copeland realized that Glanville was allowing wrong propositions of law to be explained to him, and 3, the fact that Glanville condoned Copeland lying under oath unless it was a bold-faced whopper. This mandates that Judge Glanville will not be in the courtroom in front of Mr. Williams' jury ever again as a judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including when there's going to be a witness in the proceeding. Glanville attempted to cover up his and Lawyer Love's and Hilton's misconduct by attempting to intimidate the undersigned. You think trying to throw him in jail was trying to intimidate him? And then holding the undersigned counsel in contempt of court. Sentencing undersigned counsel to the maximum number of days to serve in custody for doing nothing but zealously and ethically upholding his professional responsibilities to his client. This case can never return to constitutional normalcy based solely upon the improper misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville. A hearing must be held to properly document the misconduct between Lawyer Love, Lawyer Hilton, and Judge Glanville. A full evidentiary hearing must be conducted where Love, Hilton, and Glanville will be called as witnesses to determine the nature and scope of their relationship and misconduct. In front of the jury, Glanville will be spoken about in terms of his work as a member of the prosecution team. Oh boy. Glanville will be called as a witness by Mr. Williams. The law mandates that Glanville be removed from presiding over this case because he can't be a witness and a judge in the same case. Glanville has given Lawyer Love, Lawyer Hilton, and the Honorable Attorney Bumpus and witness Copeland legal advice. So he's saying that Glanville is giving legal advice to all these people. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. As attested to in Exhibit A, Judge Glanville received extrajudicial, that means outside of the courthouse or courtroom, extrajudicial information, and also gave opinions and legal advice that included, but are not limited to, that one, Mr. Copeland went to prison for crimes committed on behalf of YSL, which is a contested fact in this trial. Two, Mr. Williams and the other co-indictees know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. Three, Copeland will be cross-examined on his other crime evidence because Williams and the co-indictees have a far greater knowledge of Mr. Copeland and his background than the others. By embracing this extrajudicial information, and see what he's saying is that the prosecutors have told Glanville all this stuff in the ex parte. And by embracing this extrajudicial information, Glanville believes that Williams is somehow involved in criminal activity with Mr. Copeland. And Judge Glanville expressed that fact to Mr. Copeland in order to push Mr. Copeland to testify against Mr. Williams. These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate that Glanville be removed from this trial. Moreover, Glanville's derogatory, prejudicial statements and demeanor must be considered by this honorable court, that's Krause, as attached in Exhibit A. I don't think that's an unfair characterization. I think Glanville has, in many ways, engaged in derogatory and prejudicial statements and demeanor, and all that should be considered. I agree. Glanville has violated his oath of office by not voluntarily disqualifying himself to avoid the appearance of impropriety. Instead, Glanville, Love, Hilton have manufactured an unfair, unconstitutional, broken trial, caused Mr. Williams severe legal prejudice by incarceration for over 2 years without bond, and a laughable trial that has lasted entirely too long with the games played by Love, Hilton, Glanville. They must be removed instanter. That means right away. Glanville, Hilton, Love have stolen forever Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutorily firm manner. Glanville, Hilton, and Love have goaded Mr. Williams into moving for mistrials. All of the conduct, it means everything that's happened after the Honorable Douglas Weinstein Esquire, as well as undersigned counsel, filed their motions to recuse. Everything that happened since then is to be deemed invalid and have no effect, because Glanville should have immediately stopped taking any action, but he didn't. He went on a couple of weeks, right, or whatever, before he reversed course and did the right thing. So what they're saying is that everything that happened in the interim should be deemed invalid and without effect. His constitutional right to a speedy trial has been stomped on by Glanville. There's been a systematic pattern of prejudicial conduct towards Williams and his counsel and co-indictees and their counsel by Judge Glanville, Love, and Hilton acting together and unethically, which has influenced the trial process and has broken the foundation of a fair trial. There's been lots of instances where the judge is getting into it with lawyers. A lot of people are complaining about the behavior of the prosecutors. And so when Brian Steele speaks this way, which basically there's a systemic pattern of prejudicial conduct towards not only Young Thug, his lawyer, but the other co-indictees and their lawyers by Glanville and Love and Hilton acting together. That's what I'm talking about. That's what he's talking about. It says that it's influenced the trial process and has broken the foundation of a fair trial. Glanville was using his position of power and trust to obstruct justice as he's violated his oath of office, while lawyer Hilton and lawyer Love sat mute as they violated their oaths of office and their ethical responsibilities to ensure a constitutionally fair trial. By the way, he makes a good point there. The judge isn't the only one who is responsible for ensuring a fair trial. Prosecutors are as well. The law requires this court to recuse Judge Glanville. The public must believe in the absolute integrity and impartiality of judges. That is why, even without a showing of actual bias, prejudice, or unfairness, and regardless of the merits and timeliness of any motion to recuse, it's inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. So what he's doing is he's asking Judge Krause to recuse herself, and he cites a JQC opinion from 2003. Krause hadn't done anything wrong except for the fact that she's on the same court. She's also a fellow Superior Court judge. He's saying that that right there, y'all are just too close for comfort. We need to really have a legitimate sort of outside judge look at this. And it says the Supreme Court of Georgia observed that the JQC has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit. The commission concludes that it will be inappropriate for this court to preside in this action where Glanville holds a judicial office in the same circuit. An appearance of impropriety exists in situations in which reasonable minds perceive that this court's ability, that's Judge Krause, her ability to carry out its responsibilities with impartiality could be impaired. And so the fact that they're on the same, their workmates, their colleagues at the office, so to speak, and that she's received $2,000 in a donation from him, what Brian Steele is saying is that based on those two things alone, again, Krause has done nothing wrong, but he's saying that reasonable minds might perceive that for those reasons, this judge might not be the best person to decide this issue. This court has received a $2,000 donation, as I just mentioned, for its reelection from Glanville in April of this year during the pendency of this trial. Judge Glanville giving this contribution for reelection could be deemed a, quote, exceptionally large campaign contribution, close quote, and thus is another reason this court must recuse. And he cites some case law that stands for that proposition as well. And that's the end of the motion. All right, folks, before you go, just remember, whatever you do, please don't be this.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lies.
Yes, you may.